Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for July 19th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Judge, may I? Ms. Ceci is still not connected, Judge. I see that she's still trying to connect.
Oh, okay.
What's happened?
Do we have a phone number for her?
Let me get a hold of her.
So we are awaiting the court reporter to log in. Let me see. On cause number 2023 DCV 1115. Oh, there she is. Good morning, Miss Looney. Are you ready?
Yes, Judge, I'm sorry.
That's okay. Go ahead, Mr. Marufo.
Up on page 1, Judge, in cause number, excuse me, in cause number 2023 DCV 1115 Del Bravo y Mules et al. Versus Amigo Chemlight Laboratories. Announcement of counsel, please.
Good morning, Hugo Madrid here for the plaintiff, ready to proceed.
Okay, and we were set. I'm sorry. Was someone else speaking? All right. Mr. Madrid, I have a set for, looks like a default hearing, but there was a supplemental motion for default file this morning. Is that right?
That's correct, Your Honor. And I'm the one that filed it, Judge. What ended up happening is that although we attached all of our exhibits to the motion, the business records affidavit for some reason was not attached to that motion. And the business records affidavit is dated when the honor just for some reason it just wasn't attached. So I just wanted to make sure it was in the record before proceeding.
Okay, you may proceed.
Okay, Your Honor. So we're here. My client, I represent the plaintiff Del Bravo Inmuebles SDRL de CV, Judge. And on June 5th, 2001, my client and an entity named, and I just want to be careful, Judge, because these names are almost, they have similarities in the names. My client and an entity named Anglo Bravo SDRL de CV entered into a lease agreement in which this Anglo Bravo.
Mr. Madrid, you are cutting out.
I'm sorry, Judge. Not sure what's going on. Can you hear me now, Judge?
It's not a very good connection.
Let me see here. Judge, is that better?
I hope so.
Okay.
No,
If I
it's
may
not.
proceed. No?
It's still cutting out. Mr. Madrid, with the late supplemental filing that you have, I'm inclined to review this via submission rather via hearing. And if I need to come back on a hearing, I would have it set accordingly. So unless you have some objection to that, I just assume do it that way.
No, not at all, Your Honor. And I'm hoping you can hear me, Judge. No, I have no objection. If the court prefers, I can submit a proposed order to the court coordinator, Your Honor, for your review and consideration.
Okay, go ahead and do that. Myrna, if you will put that on the calendar for this Friday.
Yes, sir.
Thank you very much. Thank you,
Okay,
Mr.
Your Honor.
Madrid.
Thank you, Judge.
Who's next?
The third one on page 1, Judge.
Mhm.
In cause number 2022 DCV 0577 Katie Joel Munoz versus Timothy Eugene Myers. Announcement of counsel, please.
Robert Riojas for the plaintiff.
Yvonne Rosa for the defendant, Your Honor.
Good morning. We're here for a docket call. I didn't see anything filed recently. What are we doing?
Judge, we're still trying to get the mediation set. I'm hesitant. I'm not trying to throw anybody under the bus here. Ms. Rosa is a third attorney that we've had from the defense side in the last 3 or 4 months. Again, I don't know the exact reasons, but I understand there's been some changes with her firm. So I've struggled to get this case mediated, and we haven't yet done it. It's a relatively small auto case. It's not going to take long to try if we need to try it. But from my standpoint, we're just trying to get a mediation scheduled.
Are you all comfortable with, I will set it for a scheduling status conference in 60 days. Let me see. So that'll put us into, let's see, September. Actually, I'm thinking more October 4th. And there will be an order that your mediation deadline will be October 3rd. If we don't get it resolved in that manner, then I will give you a quick trial track, either that, or I may refer you to one of the other referral courts if we can still do that, just to get you a quick trial setting.
That's fine, Judge.
Okay.
Yes, absolutely, Judge. And as Mr. Riojas stated, I just received this case just after Ms. Marquez left. We did reach out to Mr. Riojas. Unfortunately, the time we had didn't allow for us to get the case mediated before.
That's fine. No worries. I'll give you a little bit of a window to get this back on track. And if not, we'll get you squared away with the trial as quickly as we can.
Absolutely. Thank you, Your Honor.
Thank you.
Let me ask, had you all already agreed to a mediator?
We exchanged mediator names, Judge. And I believe that both Mr. Riojas and I were in agreement to whoever could accommodate us the sooner. The better.
Okay. All righty. Then we'll just get an order on the deadline and assume you all will agree to that. Thank you very much. We'll
Thank
get you
you.
off our trial docket this week. Thank you.
Thank you.
Your Honor.
Who's next?
Bottom of page 1, Judge. In
Mhm.
cause number 2023 DCV 1705, Elliot Berg versus Alex Zamora et al. Announcement of council, please.
Robert Fuel, Your Honor. Good morning. For the plaintiff, I'm here for Elliot Berg. I'm here for Mr. Stevenson, who filed this.
Yes, sir.
He's got a conflict, and so I stepped in.
Yes, sir. Thank you.
Hopefully won't mess it up too much. We're here asking for, this is a new lawsuit. The service hasn't issued yet because we're asking for a writ of sequestration. And what we've got to, so we filed a verified complaint. And what we need to be able to show in the complaint is there's an immediate danger that the defendant or any other party in possession of the particular vehicle that we're talking about will, during the pendency of the suit, conceal, dispose of, ill-treat, waste, or destroy the vehicle or remove it from El Paso County. And this is a long story, frankly, but if you'll give me just a second, I'll try and condense it a little bit. So in the complaint, the verified complaint, the story is that this vehicle is a 1961 MG Midget, and it was going to be a gift from Mr. Berg to his father.
Mr. Fuel, I apologize. I don't mean to interrupt, but I read that complaint
Okay.
in terms of those details. But if there's anything outside of that you want to clue me in on, by all means.
Well, only that we think that those that history with the vehicle is ample evidence of the defendants showing that there's an immediate danger that the defendants will dispose of, ill-treat, waste, or destroy the vehicle, in part because the vehicle was all in one piece when it was delivered. It was supposed to be returned in one piece within 60 days, within 6 weeks, excuse me, in full repair. We have not heard from the defendants since February, and the vehicle was last known to be at the defendant's place of business in parts, apparently with the engine also in parts wrapped up in plastic. But because we have not heard from them, we don't know what they intend to do with that vehicle. And we're also informed that some of the parts that were with the engine, the motor, when it was delivered to the mechanic, are no longer there.
Mhm.
And so we don't know whether they're parting out the vehicle. We don't know what they're doing, but we have, I think there's enough evidence to request a writ of sequestration and to be entitled to one. And I think that in that connection with that request, I have to ask you to set a bond similar to a TRO bond, which I would ask you to set at $500. I don't know what damage there could be to the defendants if we go pick up our own vehicle from them. And they still have an opportunity to come into court and complain that we owe them money or we don't owe them money or defend this lawsuit otherwise. All we're doing is getting the vehicle out of their hands. They will then have a chance to replevy the vehicle. And so I have to ask you for a replevy bond, because this vehicle is a classic. It's about a $30,000 vehicle, and we're asking you to set the bond there.
I had seen that and seen the value, and I was looking to see what you all would be asking for in terms of a bond. I'll say that just off the top of my head, I was much higher than that, but
well, I wouldn't complain about a higher replevy bond, Your Honor, but I think it should be at least 30,000.
it's a value.
And I also wouldn't complain much if you think 500 is inadequate, but I think it's probably adequate for the bond for the writ of sequestration.
Okay. Anything else, Mr. Field?
That's it. I don't know whether this order that I have in front of you, Your Honor, is in front of me is in front of you. I don't know whether
I am looking at the proposed order for issuance of writ of sequestration prior to judgment. I did, and I just wanted to make sure that the first paragraph on page 2 is worded. If you could review that, please. Other than that, the remainder of the order to me seemed to be in order.
I love the way these are worded.
I'm sorry?
I said, I love the way these are worded. Sometimes, this language seems a little archaic at times. Well, I think the part that's troubling you is there, wherever it may be found, including without limitation, the removal and destruction of locks, etc.
No, that all is fine with me. I just, the very first paragraph ordered that a writ of sequestration prior to judgment be issued for the vehicle, conditioned that plaintiff post a bond in this amount payable to defendant, conditioned and approved as acquired by law.
That part is correct.
Yeah, that, I think I was a little cross-eyed yesterday at 5:30. So,
I don't blame you.
so anyway, is there anything else in terms of your request?
No, Your Honor.
Timetable for subsequent hearing, what are you requesting?
Well, I think the way we were envisioning this case developing is that we would get the defendant served. Once an answer is on file, we would proceed with discovery. We would see whether they're going to replevy the vehicle. If so, then we would have an opportunity, I think, to counter that replevy. And so we would be asking for further hearings after we get the defendant served. Really, I think the case at that point just proceeds with the complaints for deceptive trade practices and the other complaints that are in the petition, just as a normal case.
So my thought is then, of course, your request is going to be granted. I've reviewed the order. The bonds are going to be $500 and $30,000 respectively, as represented in the proposed order. What I am going to do is set this for a status conference in 60 days. I know that might be a little more time than we need, but I just want to put it a little bit further out. I don't want to hold us closer than that. And then we will see where we are at that point.
Thank you, Your Honor. That's a good timetable as far as I'm concerned.
Perfect. The order's been signed. I'll go ahead and get it filed with the papers of the court.
Thank you, Your Honor.
Thank you for your time.
Good to see you.
Good to see you as well. You're excused. Who's next?
Top of page 2, Judge. In in cause number 2023 DCV 0919, Van Lisa A. Scott versus Ernest Keith Cooper et al. Announcement of council, please.
Joshua Murphy on behalf of, sorry, go ahead, sir.
Christopher Brown for the plaintiff.
And Joshua Murphy on behalf of defendant Urquhart, Your Honor.
And Susie Ekval on behalf of defendants Gorman Trucking, Ernest Keith Cooper, and Fazil Bakra Inc.
Good morning, council. We are scheduled today. Let me see if that's the only thing we're scheduled for. Special exceptions hearing?
I believe so, Judge.
Okay, let me get there. All righty. So who filed it? Let me see.
That was on behalf of defendant Urquhart, Your Honor.
When was it filed?
Judge, this one was filed with the answer.
Mhm.
And I can give a brief background if the court would like it before jumping into the
Sure, go
reason.
ahead.
Generally, Judge, this is an accident where our client was in a pickup truck hauling a trailer, traveling down the highway. They were in the right lane. Plaintiff was in a commercial vehicle traveling behind our client, and an accident occurred. In the petition, the allegations that were made were that defendant or our client operated his vehicle in plaintiff's lane of traffic and failed to give plaintiff at least one half of the roadway. With the allegation, and this being the only allegation, Judge, there's no basis in law, there's no legal action regarding what has been alleged. So we're asking that either it be repled with a law that is sufficient to give us notice of what is being alleged against our client, or in the alternative, if it is not repled, it be stricken and the case be dismissed against defendant Urquhart.
Okay. Mr. Brown?
Well, Your Honor, I can, change it, but it's our client's contention that the truck was halfway in the road. So if I need to restate that a different way, but I mean, I don't see the lack of a cause of action here. I mean, I have the but if the court would like, I can be pleaded to be more specific if that's what the court wants.
So I'm not really hearing a response, Mr. Brown. What I'm going to do is I did review now the special exceptions in the answer filed by Mr. Murphy's client. You're going to have 1 week. I don't see a written response. I don't see an amendment to your petition. So I'm going to give you a week to get me a written response on the special exceptions, and I will have a decision on that the week after that. Okay, so Mr. Murphy, 2 weeks out from today will be, we're talking August 2nd. August 2nd. If the issues are resolved before that, if there's been some kind of replead and special exceptions go away, we don't need to come back. Otherwise, that's my marker to have a decision. Mr. Brown, if you want to be heard on that day, you need to let me know. Okay.
Okay.
I will have that as my deadline. Anything else, Mr. Murphy or Ms. Ekbal?
I don't have anything, Your Honor.
Nothing further, Judge.
Thank you very much for your time. You all are excused.
Thank you.
Thank you, Judge.
Thank you. Who's next?
Judge, may I take a second to identify some of the parties?
Sure.
Mr. Galvan. What cause number are you here on this morning, sir?
Morning, we are here for cause number 2021 DCV 4284, CityLink Trucking versus Dump Bodies et al.
Thank you, Mr. Galvan. Mrs. Parza. Good morning.
Good
What cause
morning.
number are you here on?
The same one, Mr. Marufo.
Thank you, ma'am. Mr. Chavez, what cause number are you here tonight?
Good morning. I'm here for the same cause number.
Mr. Wells, good morning, sir.
Same cause number, sir.
Thank you, sir. Mr. Bertini,
2022 DCV 0151.
on behalf of Mr. Hager or Mr. Garcia?
I'm here on the plaintiff side, Higdon.
Thank you, sir. Mr. Ray? We're ready, Judge.
Right, go ahead.
Bottom of page 2, Judge, in cause number 2021, DCV 4284, CityLink Trucking Inc. versus Dump Bodies Inc. et al. Announcement of council, please.
Hi, Your Honor, Michelle Esparza here for CityLink.
Good morning, Your Honor. Sergio Chavez on behalf of the third-party defendant, Acuity.
Good morning, Judge. Cameron Galvan, also here on behalf of third-party defendant Acuity.
Good morning, Your Honor. Jason Wells, also here on behalf of third-party defendant Acuity.
So Acuity is well represented here, as is everyone else. Good morning. Sorry, I was just trying to keep track and write down at the same time. We're scheduled today for a scheduling status conference. I realize that we have that motion to dismiss pending, and apologize if there was confusion on the scheduling, but I believe we have this rescheduled for August 7th, the motion to dismiss and a special exception hearing. The only thing I'm thinking we had the scheduling conference for was to get a trial track going. Is everybody ready to do that?
Your Honor, I think we would like to get a trial date, but we also have several updates for the court,
Oh,
if I
okay.
may.
Oh, Lord, yeah. Now you just made me look down my Odyssey events list and I see a bunch of things that I'm.
Yeah, there's a lot of things that went on. If you'll remember, there was a petition for writ of mandamus filed about the big discovery hearing that we have earlier this year. That was denied by the Court of Appeals. So that was just one update I wanted to give the court. Another thing is that after we filed our motion to dismiss, Mr. Aguilar amended the counterclaim and third-party petition. So we're going to need to revisit our motion and see if we file it again, and we'll set that for hearing again if we have to. And I believe that Acuity was also going to have their special exceptions heard on that same day. So I'm assuming, I won't speak for them, but I'm assuming they'll have to revisit those as well based on the amended counterclaim. Another thing, if you remember, we added the two owners of Dump Bodies and the Mexican company as defendants, and we've been having trouble finding and serving the father and serving the Mexican company through him because he's a representative of the company. He's sort of been hiding from our process server. So we're going to be filing a motion for substituted service soon and have that set for hearing soon. Another thing, Mr. Aguilar served us with what he called third request for production a few months ago. And he had previously already served, and we had answered third request for production. And after asking him multiple times to serve all the attorneys of record, he only served them on Mr. Mirazo again. So we missed the time to respond to those. So we're going to be filing a motion to extend the time to respond and object to those requests soon. And we'll have that heard at the same time as the motion for substitute service. And that's sort of just upcoming to be on the court's radar.
All right. Are we still wanting to keep that August 7th date?
I think we can keep it for now, Your Honor, because that still gives me enough time to amend the motion if I have to in the next few days and give Mr. Aguilar 14 days notice. So let's keep it for now, and I'll let the court know if we need to cancel it and extend it, but leaving it on for now is good, I think.
Okay. So,
And Judge, sorry, I didn't mean to interrupt you, Judge, but the same goes for Acuity special exceptions hearing.
okay. Okay, so I'm not moving anything for now, but it sounds like we may be moving things. I don't know. We'll see. And we may be adding and doing all kinds of wonderful things. So I'll go back to my original question. Do you all still want a trial date?
And
Yes,
Your
I
Honor,
thought-
on that point, if I may respond, this is Sergio Chavez for Acuity.
Mhm.
Just if the court could just take in consideration, but I think that's already been mentioned this morning, that Acuity is a very new party to this lawsuit. The third party petition was filed on May 1st of this year. Acuity filed its answer on June 19th of this year. So
Mr. Chavez, let me stop you right there.
yes, ma'am.
I feel comfortable saying that even if I set you today, you're probably looking at the latter of 2024.
Thank you, Your Honor. I think you read my mind.
So don't get nervous. Just like I was late today this morning, our docket is really busy. And although I don't know, I don't want to say you all are likely to go or not go, but I would kind of keep you in my mental notes as one that, a lot of my civil don't go, right? But you all might. And so I would probably push you back. Normally, when we're talking about a scheduling status conference, although I know this case has been pending for a minute, I understand that there's a lot of moving parts. So I would still be at least a year out. So even if I was being strict, you're still looking at July 2024. And I think our calendar can accommodate that, although I'm not real cool about setting a lot in the summer because I know people take time off. So if you all are comfortable with something like October 4th, 2024, honestly, I would like to specially set you at that time. Because if you are in 2024 and we're still headed that way, I want to make sure we have that secured for you. What do y'all think?
That date works perfectly fine for me, Your Honor.
I'm not hearing any no's. So we'll go, it pains me to say it, October 4th, 2024, with a docket call date of October 2nd. That means you'll have, everything on the scheduling order. About 30 days before that, you have your final civil pretrial. Mediation deadline is the Tuesday before that, Wednesday. We'll get all our other dates. Please come to an agreement on the mediator so I don't have to select one for you. We should have plenty of time here. We'll get you the court scheduling order for everybody to sign off on. We'll have our setting in. I just assume have our scheduling, like the return of the scheduling order, be due on August 7th as well. So Myrna, if you'll have that down for that 10 a.m. slot as well for them to have the scheduling order returned. Okay. Yeah, just not so as we're not giving you all too many settings. All right. Anything else?
Nothing.
Mr. Aguilar, you've been way too quiet this morning.
I'm enjoying listening to everybody. I'll go along with the game plan because I was served with the lawsuit from Acuity on Monday. The one thing I'd like to know is who is lead counsel for Acuity, because I have 4 different attorneys, and according to the rules, I'm supposed to serve lead counsel, but I got Mr. Chavez, Mr. Wells, Mr. Galvan, and Lindsay Gorbach from San Antonio. Who's lead attorney?
That's a fair question.
Lindsay Gorbach is going to be the lead attorney.
Who is? I'm sorry.
Lindsay Gorbach is the lead attorney. Mr. Sergio Chavez is Chavez is our local counsel.
So let me ask each party to please file some type of designation because it's helpful for us in Odyssey and how things get e-filed and all those wonderful things as well. Thank you, Mr. Aguilar.
Okay. Can I be excused?
Does anybody have anything else? If not, y'all are excused.
Thank you, Your Honor.
Take care.
Thank you, Judge.
Judge.
Thank you. Who's next?
Second on page 2, Judge.
Mhm.
In cause number 2022 DCV 1835, Lorenzo Juarez versus El Paso County, Texas. Announcement of council, please.
Ray Martinez on behalf of plaintiff.
Morning, Your Honor. Jed Unterrecker on behalf of the county, and I'm standing in for Michael Gomez today.
Great. We have this set for a motion for continuance. I want to say I've seen it, or we've discussed it kind of informally before. What's going on, Mr. Martinez?
I'm not sure what the issue is. I'll be candid, Miss. I've never talked to Mr. Udiker, who's on the line for the county. Mr. Gomez was opposed to our continuance. I was very confused why. We filed this case basically last June. We didn't put the scheduling order together in October. It has to deal, it's an employment discrimination case. There's a lot of disparate information we need to gather. It turns out that there's a GPS and other type of technical information where I need to take information from other people outside, even his department. We took depositions in March, latter March. We haven't received the copies of those transcripts yet. I know there's a number of discovery issues I addressed with Mr. Gomez. I tried to confer in person, and we've had some trouble connecting on that before I file a motion to compel. Long story short, I discussed this with him probably a couple months ago, and eventually I just had to file the motion for continuance as opposed. They filed their response basically saying, I'm not sure. I mean, I guess basically they just said, I just don't get one, and they want to limit my discovery going forward. I'm a little confused, and frankly, I'm going to modify how I treat scheduling orders with Mr. Gomez in the future if he's going to continue to object to routine discovery, especially in more complicated like this cases like this. I know they want to file and hear their plea of the jurisdiction before I get the opportunity to either compel discovery or take additional discovery. Maybe that's what's going on. I'm not sure, but I basically have a continuance motion in front of you. I'm hoping to push the discovery and the trial, at least 8-9 months so we can finish what we started.
And Mr. Unterrecher, I did briefly see the response, but by all means proceed.
No, I know, Your Honor. For us, it's the fact that there was an agreed scheduling order, discovery ended in June, and this seems to be an attempt just to really extend discovery past when the agreed deadline was. We're trying to move this case along. We've not heard specifically what Mr. Martinez is asking for. I guess he's mentioned the GPS. He's mentioned some other people that he wants to talk to. We haven't seen those requests. We don't know who those are. Nothing has been narrowed down for us. We want to keep this case moving. We waited till the end of discovery so we could file our plea to the jurisdiction and move along. And that's it. We're not trying to be obstructionists at all. Mr. Martinez and I go way back. So while we've not spoken on this case, he was one of my mentors when I first came to El Paso. So no, we're not trying to be obstructionists. We just want some sort of kind of clarity as to what's being sought and how much information.
And you're kind of reading my mind there, Mr. Unterrecher, because I'm about to flip back to you, Mr. Martinez, is what exactly is outstanding? I mean, we have the plea to the jurisdiction set in a few weeks, a couple of weeks, August 2nd. But obviously in the interim, and I think since we were here last time, because I feel like although there wasn't a motion, it wasn't heard, we were talking about these things, but I don't know that I was clear. What is outstanding? What is outstanding that needs to be done to make that trial date if we were to get there?
Well, first of all, we would need transcripts. We would need copies of the discovery that we already had. We need to have a discovery conference regarding the discovery they haven't produced. We need to have additional discovery regarding how other employees were treated. So long story short, Judge, this case is about a termination of a county employee. There's GPS trackers on vehicles. And so there's a dispute, or basically I'm having trouble gathering how this information is available and how other information is being processed for other persons who are not in the protected status, who are not engaging in the protected activity of my client. I don't.
Let me stop you right there. Okay, so there's one thing. Were these things that you had previously requested from the county?
Yes, ma'am. There's so when we initially filed the case about a year ago, obviously we had to issue written discovery, disclosures, things like that. We tried to schedule, and I think we did promptly schedule depositions. Those took place after discovery responses were returned, approximately about 2 to 3 months later. After that, basically, we haven't got the transcripts for those depositions. I can just speak for myself. A lot of times I review depositions in order to see if there's follow-up requests for production, to see if there's additional witnesses. I'm still waiting on that information. I've indicated to Mr. Gomez, again, Mr. Utica has not been involved in this case, but the bottom line is, I felt it was a little unfair in that when he was responding to me, basically he was saying, too bad, so sad, we're going to file our plea the jurisdiction. When I get to this point, again, I just need to think that, I need to build in additional time when I deal with county. I can't think of any other way to address this. The county basically is countered by saying, well, then limit your discovery going forward. I need to file a continuance to the plea of the jurisdiction that's set. I literally don't have the depositions of their witnesses. I don't. I don't know. And I've asked Mr. Gomez to postpone or let's work together. He's refused to do so. I don't know if it's me. I don't know if it's this case. I'm not sure. Maybe they treat every employment case like this. I'm not sure, but I do think that we just don't have that information. And I wish I could tell you there's 10 things I need. I have no idea. I don't have the transcripts from their witnesses that we took in the end of March. And so I'm kind of stuck. And so that's why I thought the easy fix to this was to continue the trial, to continue discovery, and basically set the plea the jurisdiction hearing at a time when I could actually get this information.
Mr. Unterrecher?
Yeah, I'm not sure what the holdup is with the transcripts. They happened in March. It's now 4 months later.
So yeah, again, I'd not to interrupt Mr. Utica. He's not been part of this situation. And again, Mr. Gomez has been the only person I've contacted. Long story short is the court reporter. And again, I don't want to disclose too much, but long story short, there was a significant illness of her husband. And I know that impaired her ability to get these transcripts out. I think that she's even, basically sent these transcripts out to other persons. I know there have been multiple requests by both sides before we found out this information. And unfortunately, when I found out, it's kind of hard to deal.
So there may be several factors that are contributing to some types of delay. Okay,
Yeah.
we're here. I was going to ask you, Mr. Unterrecher, to respond, but I feel like I would like to do this. We were set for the motion for continuance today. What I would like to do is allow Mr. Martinez and you, Mr. Unterrecher, to have about I'm going to reset this 1 week. 1 week. I don't think that gets us. I know it means we're going to have like weekly hearings leading up to a plea of the jurisdiction to maybe get a better handle on the different things that may be causing delay. I don't see there was ever any type of motion to compel, but it sounds like what you're telling me, Mr. Martinez, is that you were working with Mr. Gomez with some of these other things that might be, can I say, the building block to other requests for discovery you may have had if you had received things timely. I'm not really sure. What I need you two to do is to confer on exactly what is outstanding, to see what can be completed so that I have a better understanding from you, Mr. Martinez, what remains outstanding. I know the position may not be any different. Judge, we're going to need more time and we're going to need more time on the jurisdiction. I understand that, but I want a better handle of what we really have outstanding and make sure that this is not just maybe miscommunications or things that have fallen through the cracks in the interim because the timetable is somewhat short. What I don't see in here, and maybe it is, Mr. Martinez, and your motion for continuance is on the plea to the jurisdiction, that request for a continuance. Is that?
Yes,
in-
I was waiting to address that today, and again, I was just assuming Mr. Gomez just wasn't, I don't know, it was just an odd situation, but I think we will need to file a motion to continue, and I assume it'll be opposed as well, of the plea of the jurisdiction to give us adequate time to collect discovery that's already been issued and to conduct additional discovery.
Okay. In any event, I'm simply not inclined to rule on the motion for continuance just yet. So we can come back in a week, or we can come back on the date of the on the August 2nd date. It's up to you all.
Yep, for me, really any time. I know next week I'm actually going to be out of town on a visiting colleges for one of my sons, but I can participate through
No.
video.
We will just go
at
with the
any
August
time.
2nd date. We'll just go with the August 2nd date. But I need your filed motion for continuance on the plea of jurisdiction before that.
Yes, ma'am. What I'm going to do is file the motion for the continuance of the plea of the jurisdiction. I'm going to forward Mr. Udiker which discovery requests and interrogatories that we've previously addressed, and I'll basically try to get a quick answer so I can put that on file as well. And then I don't know, I guess give more of a clear statement about the depositions that were taken in August, or I'm sorry, in March.
Mr. Unterrecker, do you have some input here?
I was just say that I will interject myself and put myself in the case here and work with you, Mr. Martinez, on this, and Mr. Gomez, to get this hashed out.
Okay. Yes, Mr. Martinez, just get that before you go college visiting. Please have your motion on the plea of the jurisdiction filed. Okay.
Well, yes, ma'am. We'll get that on file this week.
All right. Thank you very much. Thank you, gentlemen. We'll see you on August 2nd if I don't hear from you sooner.
All right. Thank you, Judge.
Take care, guys. Bye-bye. Who's next?
Middle of page 1, Judge.
Mhm.
In cause number 2022 DCV 0151, Pablo del Rio et al. Versus Lorraine Herrera. Announcement of council, please.
Chris Bertini for the plaintiffs.
All right. Final status conference. Is it Jose Garcia or is it someone else?
Judge,
I don't know who's handling this for the other side, Your Honor.
Judge, I made a call to Mr. Garcia at 10:45, no answer. Again at 10:52 and left a message at 10:52.
Okay. Do you know Mr. Let me see. Here we go. Designation of attorney in charge. Yep. Did we call those individuals Garcia at MDZ Legal Group Law? Is that Garcia? He's the designated attorney in charge. Is this the gentleman? Yeah, from South Texas. Mr. Pertini, have you had any contact with defense counsel?
We mediated this case
Oh,
about 2 weeks ago, Your Honor. I was on vacation and I missed the last hearing. I wrote a letter to the judge apologizing. We mediated the next day. We did not settle. I don't know where defense counsel is. So I can't, other than that, we're ready for trial on September the 8th.
okay.
My question is, that's a Friday and I'm not familiar with how the court does things.
Sure. So what we do is September 8th, we would pick a jury, and if I can quickly get to my court calendar. Yeah, we have just the courtroom. Well, we have it on both days, but for this case, I don't think we would need it. And we're in the courtroom. So it'd be 2 panels. What I will say is this, if I'm not mistaken, Myrna will need to put in a request for a visiting judge for jury selection on September 8th. And let's see how that goes, because it's the annual conference. It's the annual judicial conference so we might be slim, but I'll find you someone to get your jury. Yeah, we need to continue Ms. Hernandez and Mr. Marufo to follow up today with Mr. Garcia. Mr. Bertini, thank you for your time this morning. We're just going to keep our trial track. I mean, if you all went to mediation like you were supposed to, didn't work out. Was this one that Mr. Garcia was saying it was difficult to locate their client or something?
I don't know, Your Honor. I inherited this case and I apologize. I wasn't at the last hearing. I don't know what their situation is on their side about locating clients. I'm usually not privy to that since I'm opposing counsel.
Well, if you went to mediation, yeah, I don't know.
I mean, it was an insurance adjuster attended the mediation.
Right. Yeah.
My clients were there.
I may go back and look at that YouTube hearing from the last time. I think I'm remembering Mr. Garcia, but I don't want to make a mistake. In any event, we're on track. You're on track for trial, and we'll let you know if something changes. Okay.
And again, personally, I want to apologize for missing the last hearing. I flat out.
I saw the
vacation.
Just. I saw the letter, and I'm not sure I fully answered your question. We would select a jury on the 8th and start evidence on that Monday. Okay.
It'll probably be a day and a half of evidence, Your Honor. So.
Okay. Well, I don't have a problem if we can get counsel here, coming back for our final civil pretrial. If you all, if we do have a visiting judge for you that day, to have evidence start that day if you get the panel done. I don't know if that makes a difference to you, but we can discuss it whenever counsel decides to get here.
We got another hot month left between then and now. So.
Yeah. Another stretch of 30 days of 100 degrees.
I know. Tell me about it. It's not too pleasant over here in Houston either. So
I can't imagine. Thank you for your time, Mr. Bertini.
Have a beautiful week, Your Honor.
Take care. And who's next?
Second on page 3, Judge. I believe this is Mr. Hibbler.
I'm sorry, second one on page 3?
Yes, Judge.
Oh, okay.
In cause number 2023 DCV 2025, ex parte Jimmy Lamont Hibbler. Announcement of counsel, please.
Excuse me. Jimmy Lamont Hibbler. I would be representing myself in this matter.
Okay, give me 1 second, Mr. Hibbler. Let me see.
Yes, ma'am.
For your patience this morning. Let me just pull up your case very quickly. Is this an occupational license due to a DWI suspension?
Not a DWI, but yes, ma'am, it was due to a suspension for citations.
Oh, okay.
Driving citations.
Gotcha. Let me go back. Case screening, related case. Give me just a second, Mr. Hibbler, so I can review the petition, okay?
Yes, ma'am.
So under your petition, it says here the JP3, I guess there was some type of, well, what was the nature of that? I haven't looked up the citation that's listed here.
As far as I can remember, ma'am, it was a speeding citation received back in 2027. I had made quite a few attempts to have a court hearing scheduled. From what they were telling me, notification was sent out. I never received the notice. So when I made a second attempt to set up an actual hearing, they denied my request. So in turn, instead of trying to go through a whole lot, I just went on ahead and just paid the citation. Given the fact that I'm here in El Paso and where the citation was received was somewhere around Weatherford, Texas, which is quite a ways away from here. It's closer to Dallas than it is here.
Okay.
So soon after I took care of the financial responsibility on the citation, when I went to take care of everything for my license, that was when I noticed that I needed an occupational driver's license in order to renew my license.
So one thing I'm looking at and looking at your petition, and maybe Mr. Medina, if you can help me here, I see two entries on where I'm seeing the petition. I don't know the title of it. There's one that's 8 pages. There's one that's 5 pages. What I'm looking for is I do want to see the certified driving record from DPS. Did you provide that?
Unfortunately, ma'am, I did not.
Okay. Are you having trouble doing that, or?
Yes, ma'am. The day that I went to get everything scheduled so that I could have a hearing, I tried to go online, was moving around, and couldn't really find something that was legit in order to request my driving record.
Okay, so at the very least, I mean, I'm seeing your petition, and quite honestly, Mr. Hibbler, I'm not, I don't really have an issue, but I do want to see the copy of the certified driving record and your either SR22 insurance or any proof of insurance that you have, because those will be requirements, the insurance for sure, and my satisfaction in terms of determining whether or not you get the occupational. I really don't have a problem with it, but I need to see those things. So
Yes, ma'am.
I see
I
that
do
you
apologize.
filed basically what is the affidavit in terms of finances. I'm trying to get a handle of what the holdup might be. I could reset you for 1 week if you think you can provide that documentation.
Yes, ma'am. But the SR22 was given with the affidavit, with all the paperwork that was turned in. The SR22 was under USAA.
Mr. Medina, do you see that anywhere?
No, Judge, I'm not seeing it anywhere.
I have, let me see what's on 8, because there's one thing that is 8 pages, but that's not it.
No, ma'am. The SR22 was only 2 pages, and I turned that in the day I gave the petition.
So this is what's going to happen. We are, can you follow up with this within a week's time? And I'll tell you this, if you have the SR22 or insurance information, by all means, just email it to the court. I'm going to put on here Ms. Hernandez's email. Are you able to see the chat, Mr. Hibbler?
Yes, ma'am, I most certainly can.
Okay, it's my.hernandez@epcounty.com. If you have the SR22, it's not showing up on the entries in our system, okay?
Yes, ma'am.
So just email that document to her. Also, if you have a copy of your DPS driving record or can acquire one, same thing, just email it there and reference your case number 2023 DCV 2025.
Yes, ma'am.
Do you think you can do that before a week's out, or how quickly?
Yes, ma'am. I should be able to get that taken care of today. As a
Okay.
matter of fact, not should be, I will be getting that taken care of today.
Okay, I'm going to reset you for 1 week. I'll tell you this, if I receive that documentation here, what I don't also see, is there a proposed order? Mr. Medina, do you see anything in terms of the occupational license order?
No, Judge, I do not see a proposed order as well.
I also need the order that would go with your petition. So you're saying, I would like this occupational license. Do you have if you have the proposed or drafted document that is your actual occupational license, please forward that as well. Myrna, we may need to look for one. The only thing is going to be, it's a little different because it's not for a DWI suspension.
Yes, ma'am. But Your Honor, the only question I have is in reference to the order, because everything that I brought in the day that I was trying to get everything taken care of, I had the petition and that was it. Well, the petition and the SR 22. I wasn't aware that I needed to bring in an order. When I asked the question at the front desk, I was, and I understand, but I was told that they couldn't really give me any legal advice.
Right.
But as I went through everything that was needed, or in there, did I see an order?
Okay. See what you can find if you can. Ms. Hernandez, I know we've had an occupational license here not too long ago. If you can send me some drafts of orders that we've recently had, we may be able to utilize one, but I want to make sure that we're not including stuff that doesn't apply to you, because as I said, usually our occupational licenses are DWI related.
Yes,
Okay.
ma'am. Understood.
All right. In any event, 1 and 2 is the driving record, SR 22. If you find that you somewhere in this paperwork that you've utilized or people have provided to you, you see something that is an actual occupational license order, please forward that as well. We're going to look and see if we have one. Okay.
Yes, ma'am.
All righty. Any other questions?
No, ma'am. I only have a comment, and that's thank you for your time.
Absolutely. You have that email there. That is the court coordinator. Our phone number is 546-2130. If you have any questions before the next hearing, and we'll get you your setting. Okay.
Yes, ma'am.
Do we have your email?
I'm not too sure, but
Put it in
I
the
will.
put it in the
Yes,
email to
ma'am.
Ms. Hernandez. Okay.
Yes, ma'am. Oh, understood. Yes, ma'am.
All right. Okay. All right. Anything else?
No, ma'am. You have yourself a very blessed day.
Same to you. Take care. All right. Is that everybody?